Okay, good morning and good afternoon, wherever you might be around Australia or possibly New Zealand as well. Thank you very much for joining us today on the Q3 BICSI South Pacific update. My name's Craig Buckingham. I'm just hosting the thing. I'm not presenting. We've got three far more capable people than myself to do that for you today. I'm just going to quickly take you through the platform so you're familiar with it should you have any questions. So you should be able to see on your screens right now there is a questions option and also a chat option. As the presenters are talking, if you have any questions, please feel free to drop them in there and I'll just monitor them as the session goes on. If your question is relevant to the topic at hand, I may interject the speakers and ask the question on your behalf, or I may just stack them up to the back end of the presentation. Similarly, on the chat side of things, that will be monitored as well, but please don't put your questions in there. Paul will cover this off in a moment anyway, but this session is being recorded, so please keep that in mind with any interactions you may have on those sort of verbal questions, etc. And it will be available on the BICSI website after a few days once BICSI have uploaded it from their side. That's it from my side of things. You probably won't hear too much from me throughout the session unless a technical issue or I'm asking questions on your behalf. So thanks very much for joining once again, and I'm going to hand over to Paul and mute myself.
Thanks very much, Craig, and thanks to R&M for facilitating this webinar this morning and this afternoon. Well, welcome, ladies and gentlemen, to our yet another BICSI webinar. We're delighted that we have the program running in full swing now every second week, every fortnight. From my understanding, we have people from as far east as Fiji joining the program. We've got folks in New Zealand, all parts of Australia, and I believe we have a few from the US listening in as well, and a couple of gents in Japan. So we're almost going global. The thing I should stress about today's webinar, it is very much Australia focused because it deals with Australian regulations and legislation. However, the principles that are being delivered by our two experts will basically cover off into other areas. So if you're not from Australia, bear in mind some of the principles, and I'm sure you'll find some value in that. Just to kick off, we've got just a few slides just as a bit of an opening introduction, and then we'll only hear from myself for a few minutes, and then we'll hand over to our subject matter experts. And as Craig mentioned, if you could direct your questions, comments on the webinar to the moderator, to Craig Buckingham, by the chat box you'll see on your control panel. We're going to allocate some time at the end. If there's a group of questions, we'll see how we go. If there are lots and lots of questions, then we'll basically accumulate them, and then perhaps rather than let the webinar go on forever, we'll basically close the webinar and then capture the questions and forward them to our subject matter experts, and they'll be able to individually respond to you. An important point for our credential holders, we are seeking CECs with BICSI US on this particular one. It's a 1-hour event. It won't happen immediately. We are doing it progressively. So before the end of this year, we'll definitely ensure that you will receive your CECs for this particular webinar. Just the program, you've got 5 to 10 minutes from myself, and then we'd like to introduce Gary Rowe, the CEO of Safety Action, and Andrew Douglas, the Managing Principal from FCW Lawyers. They're going to talk for about an hour on safety and contractor management. This is an important topic. I've had numerous discussions with both Gary and Andrew over the years. Our world is contracting and subcontracting, whether it's design, whether it's installation, whether it's supply. There are so many OHS issues that just linger around. Many of us assume we know. Most of us haven't got a clue, and most of us are just lucky that we haven't ended up with a problem. Today's webinar is an attempt to just give you an overarching view of our responsibilities and things that we can do to mitigate some of these risks. So this is an exciting topic that we're going to share. We have a number of BICSI registered cablers with us as well. So we've welcomed you to this event, or invited you to the event, because this is the world you live in, and we're sure you're going to earn some valuable knowledge by attending this morning. Just a quick recount of the webinars that we've held so far. Since the start of coronavirus lockdown, we've run a number of webinars. There's some technical topics, there's some building topics, and now there are some legal topics that we're talking about. As Craig mentioned, on our website, you can access all of the previous webinars that have been recorded, and we're going to record this one as well. And in 2 weeks' time, we've got another one, air containment in healthcare facilities and data centres, specific looking at essentially fire stopping and smoke stopping, but also courtesy of our coronavirus situation, contagion containment as well. So we'll send out some reminders about that in due course. And just a thank you to both Fluke Networks and R&M for facilitating their webinar platforms, Fluke with WebEx and R&M with GoToWebinar. They've been running flawlessly, so we thank them enormously for their valuable support and assistance to make this all happen for us. Okay, just a quick touch on COVID-19 restrictions. We're in Victoria. Many of you are in Victoria as well. We've had numerous phone calls and emails inquiring from our registered cablers, what's the impact? I'm not going to address that here, but what I put up on the this particular slide is some of the issues, the impact on our industry, the ICT infrastructure industry, the impact on the construction industry, where most of us work within. There is a plethora of documentation available. We've been doing truckloads of research over the last few days just to understand what we can do as an association supporting this industry so that we can help you to understand what you can do within the industry. We put out a circular on Friday with some information. We've been monitoring the Victorian Government website. There is more information, and we'll put out another notice or another circular out to registered cablers on Friday with some further assistance. But by all means, if you have any questions, feel free to contact us. We don't have all the answers, but we can direct you to the areas to go to. One area that I've been gleaning a lot of helpful information is Andrew Douglas's Friday briefings. Andrew will talk about that in his presentation, but where the focus has been on what do we do as industry in view of coronavirus, and particularly with Victoria being under such heavy restrictions now. A lot of discussion, a lot of uncertainty. Where do you go to for information? So hopefully we'll be able to assist you with that. So by all means, feel free to reach out to ourselves or to Andrew or to Gary after this webinar. Just a quick one on our online courses. There are many, many courses available. One of the things we're encouraging folks to do if they're in lockdown situation, use the time to your advantage to get an education on various areas. There's a list of some of the items. BICSI's putting up a lot of its courses at no cost and or discounted. Many of our corporate members, their Comscope, Simon, Annex, R&M, Fluke, they've notified us of their free courses. Our accountants, Mazars, have also told us that they've got some free webinars on basically tax issues with around coronavirus. There we go. There's Andrew Douglas's legal issues, his Friday briefings. CEDIA, AVICSA, the AV associations have done the same sort of thing. So by all means, take advantage of the education, the free education that's available at the moment. Perhaps it helps you with filling in the time, which is important, but also enhancing your education and your knowledge about things that will happen, that are happening now, and things that will happen in the future. One last slide, just an update on our conferences. Many of you are aware that we've had to cancel all of our conferences this year. So the New Zealand conference is now booked in for the 11th of May next year. The Australian conference hasn't been booked as yet, but we're looking at Q4, so that's going to be typically October or November in Sydney. We are talking to a couple of venues at the moment. We'll let you know a little bit more about that. And the BICSI US 4 conference, which is a big one, that was going to be held in Las Vegas this year. Unfortunately, courtesy of coronavirus, the decision has been made to host it completely virtual. They did explore hybrid, physical and virtual for a while, but of course, now that the restrictions are even stronger in the US, it's gone fully virtual. The good news for that, for us, means that we don't have to physically travel to get access to one of these fabulous conferences. If you go to that link, you'll find all the details to log on or to register to attend, get the full benefit of the fabulous content that's presented, the great educational material, and also seeing the exhibition in virtual capacity. So that's a good way to do things. Anyway, I will then conclude there and hand it over to Andrew Douglas and Gary Rowe to lead us in our primary discussion on safety and contractor management. And you'll see SWMS and JSAs have been part of the focus. Over to yourself, Andrew.
Okay, thank you very much, Paul. Thanks for having us along. Gary and I have worked together, I think, for too long. We're both old grey-haired men, so we've spent much of our professional life working together. Gary and I, between us, have done hundreds of serious injuries and fatalities. and Gary is the person I go to provide expert safety advice when we're rolling out a legal strategy. So Paul, we might just move very quickly through the first couple of slides if we can. This is Gary and I looking younger. We'll move on to the next slide. We like that slide, don't we, Gary? That's good. This just to remind you, this is not legal advice. We're going to talk to you about some issues. You can always dig a bit deeper and ask Gary or I more detailed questions. If I go on to the next slide. Okay, the reason we're talking about contractor management is there is so many lies out there about how we manage contractors. There is an assumption that exists that if I enter into a contract with a contractor, I can, through the contract, force that person to be responsible for their safety and for anyone else's safety around them. And I just want you to be really clear that's not true. The safety legislation stands over the top of all contracts and carves straight through them. So what you can do is you can allocate work out and responsibilities, but you can never, as a principle, ever get rid of your obligations. Now we'll talk about how you manage that because that's what this is about. It's about contractor management. But you cannot carve out of your safety obligations. Now we talk about, and Gary and I will talk for the rest of this seminar about, well, how do I carve out that responsibility in a reliable way which protects me from being litigated against? The contract is certainly part of that because that identifies where the responsibility should be, but it's how you behave in procuring the person, monitoring and managing the person, and the ultimate review of that person, which guarantees that you'll be safe from prosecution. It is true that contractors are responsible for their own safety, so it's not all a lie, but you are as well. That's the trick, okay? I'll tell you how that works in a minute, but I want you to understand that throughout safety law, everybody has their own personal duty they cannot delegate. But as a principle, a person who is control of a site as a whole, they have the responsibility for everybody. And everybody else has their own responsibility, and they can have responsibilities that go back towards the principal depending on their action. But don't think they're responsible alone. They're not. There's also this sort of crazy story that goes around that as a principal, you know, you mustn't monitor, you mustn't intervene if something's dangerous. Well, there's some very interesting cases where principals are aware of a risk and haven't intervened and been prosecuted. So let me be very clear with you. The obligation of a principal or a contractor who's managing a subcontractor is always to monitor, and if there is a risk, to intervene and to require that contractor or subcontractor to demonstrate immediately what is the system they have in place to ensure it is safe. And if you're not satisfied with that, you must stop work. Now that is a contractual power that you have. And if your contract doesn't have it, that's a very, very big mistake, okay? And the last part is, look, if it's dangerous, I don't have to intervene. It's not my problem. The contractor's managing it. That's all their risk. That's just utter garbage. If it is an observable risk to a principal on a site, the principal must intervene, okay? You can't just close your eyes and say, I didn't see it, I didn't see it, I didn't see it. And all major contractor cases invariably have both the principal and the contractor liable. So let's move on to the next slide, Paul, and talk a little bit more. And don't worry, Gary, you're going to get a run very, very shortly.
No, that's okay. I thought Andrew might be an interesting question for me, if I may, with what you've just outlined with those duties that you can't and obligations you can't avoid. We've got people from around Australia and outside, but I think it's true everywhere. The new manslaughter, industrial manslaughter laws, has that changed that landscape much? And so is that sharpened the focus at all?
So yeah, look, good question, Gary, because industrial manslaughter, when we look at Australia and New Zealand, for instance, it's not in New Zealand. There is some discussion in New Zealand about bringing it in, but it's not part of the law yet. So it's part of the law in Victoria from 1 July. It's in the Northern Territory. It's been in Canberra or the ACT for some time, and it's been in Queensland for a few months. And in Queensland already the first case has come through, as in the ACT. So what industrial manslaughter says is, if I can see a breach of duty, if I know that that breach of duty had a likelihood of serious injury or death, and it actually caused death, and there is a high level of negligence that attaches to it, then you will be liable. And you're right, Gary, this goes to the very heart of principal obligations. Because the principal always has a duty over its entire site or operations, therefore any breach of that duty by any person ticks the first one. The second one is, well, what is the system that the principal has to satisfy themselves that that breach can't occur? And if it's demonstrated that there is a system, but they are totally negligent with it, and the result of that risk that was exposed was the likelihood of serious injury or death, and death occurred, then you're liable. And in places like Victoria, that's 25 years jail, it's $16.5 million fine. It's serious stuff. And it's much easier to prove industrial or workplace manslaughter than reckless endangerment, which is the traditional part that sits in all legislation across Australia and New Zealand. Okay, and reckless endangerment says I'm aware of a risk, and I've got to actually have it's called, the recklessness part of it is a criminal term, which means an actual knowledge of a risk. Okay, so it's subjective and objective. It's a very complex term. It means I'm aware of a risk and I ought to know that that risk has a likelihood of causing serious injury or death, and that I'm indifferent to it. But you see, there's the trick, there's the state of mind. How do I prove someone was indifferent to it? Very, very hard. It might be, get on and do that work, I don't care if it's going to kill you. Okay, well then that's not so hard. Whereas industrial manslaughter, all it's got to show is that the level of negligence was so high. So it doesn't have to prove a state of mind. And you look at a major construction site where a principal contractor is running a site that has 40 or 50 contractors. The first thing you're going to look for is a very substantial system that ensures the site is safe and that everybody working on that site is capable and competent in safety. Now, if you don't have that system or it's demonstrated it's not working, and you ought to have known it wasn't working, and it's actually exposing people to the risk of death, and someone dies, you're straight into industrial manslaughter. Does that make sense? That's a very long answer. You'll never ask me a question again. I know that now, Gary.
No,
so,
excellent. Thanks, Andrew.
So why is it wrong? Anyhow, why are the lies that we talked about wrong? First is everyone has a duty. The second thing is that contractors in Australia and New Zealand are deemed workers. So Section 21(3) in Victoria says contractor is an employee. Section 19 under the WHS says contractors are workers for the purpose of the Act, and there's a similar provision that exists in Western Australia. So the reason it's all a lie is that a contractor and their employees, as a matter of law, are deemed employees or workers under all safety law in Australia and New Zealand. So saying they're not is just garbage, okay? Being ignorant is no excuse in the law, just no excuse at all, okay? And we've talked about industrial manslaughter and reckless endangerment as to, you can see now why a principal, a person running a site, or a contractor who's got a subcontractor. Now, and we'll talk about subcontractor risk later on, because most major contractors now, to maintain the ebb and flow of workers that come through, actually have quite a narrow band of employees, and they fill the gaps, sometimes with specialists, but more often not specialists, but with just labour to actually do the work. And that labour forms the basis of a subcontractor. It may be through a labour hire business, or it may be a builder who comes in who works under the major builder. But as they're pulling in these subcontractors who aren't being inducted properly, who aren't competent, who aren't capable, who weren't part of the tendering process at all, they're rogues. They're in the site and they're rogues. They're uncontrollable. Their margins are so small. They're not safe. So if you run a site and you know you've got that risk and you don't have a system to manage it, you're not just in breach of duties, you're percolating up towards reckless endangerment and workplace or industrial manslaughter. And the last thing I will say is, in Victoria, workplace manslaughter, as it's called in Victoria, it's industrial manslaughter, extends to third parties. So it doesn't anywhere else in Australia. But if you kill someone who comes onto a site, okay, it doesn't have to be an employee, you can be guilty of workplace manslaughter. And industrial and workplace manslaughter throughout Australia also extends to death off a site. And there's a particular case with mental health issues. So if you've got a system and it fails to manage mental health, it fails to manage the pressures that are being placed on people, it fails to managing bullying, and somebody, as a result of the treatment they've had on site, leaves the site and they walk across the road disorientated, stressed, don't observe a car coming and they're knocked over, you can still be guilty of industrial manslaughter. So I think it's pretty important when we say, why is it wrong? A, everyone's got a duty, and you've got a duty as a principal or as a senior contractor for everyone who works for you. Why? Because the law says that a contractor is a worker and the employees of a contractor are a worker under all safety legislation in Australia and New Zealand. And you can't turn a blind eye, you can't be ignorant about it. And the last part is, if you don't have the system, and Gary and I are going to drive it home about systems, I'm sure Gary certainly is. If you don't have a system, you're heading towards industrial manslaughter, not just a primary breach. Okay, Paul, let's kick on, mate. All right, specialist contractors is the place where most people go, look, if we use a domestic circumstance, and of course domestic circumstances aren't covered by safety law, but if I bring an electrician into the house and they go to work on my lights, I assume they have skills, and he rightly assumes I have no skills at all, okay? So I'm relying on his skill and expertise to not only do the work, but to do it safely. And that's why the domestic situation doesn't work in the business situation. Because if I bring an electrician to my workplace and I ask that person to change the lights, well, I do realize they're going to have to climb at heights and they're going to be above 1.8 meters. I can't actually ignore that fact. That's not something that's peculiarly in the knowledge of the expert. That's something that is in the knowledge of the organization. The only expert knowledge he has is dealing with the electricity when he's doing the lights. The rest of it, the circumstances around it, is the knowledge assumed in all principals. And if the principal has the knowledge of expertise but chooses to get someone else to do it, they can't pretend the specialist takes the risk. Make sense? So if I've got electricians who work in my business, but I bring in an electrician to go and do the work, I can't then, when I'm doing my SWMS, because that electrician is working amongst my staff, I can't then pretend I don't have the knowledge of risk. I must actually engage with the knowledge of risk that I have. So we do use specialist contractors. We do them for a defined task. We use them because we normally don't have the skill. If we do have the skill, the responsibility stays squarely with us. Be very clear about that. To the extent that their task has specialist knowledge and therefore the hazards that arise as a result of that task have a specialist knowledge, we are entitled to rely upon them, but we must be inquisitive. That means we can't just say, oh, go and work over there, mate, off you go. Because our obligation as a principal with somebody coming on our side is to develop a document between the two of us as to how they're going to work. And what we're going to try and do is give them as much control around the space so they have the least amount of intervention with other people, so the risk doesn't come back to us. But we sit down, whether it's a JSA or a SWMS, we're going to go and say, look, the risks that are within our knowledge and control are these. The risks that are within your knowledge and control, which we don't have knowledge of, tell us about those and how you're going to manage them. And that's the obligation when you're dealing with a specialist contractor. So you can transfer responsibility to do the work, but you can't transfer the legal obligation because it never leaves you, okay? The only way, and Gary and I keep saying this to people, is please create a risk assessment document, whatever it is, that demonstrates and separates out what is your general knowledge that you're applying, what is their specialist knowledge, and interrogate against it and give responsibility. Now, we'll talk more about SWMS and JSAs and whatever you want to call these documents later. But I guess my point is, Gary, the difficulty we have with most people is they simply don't document who's in control and how to do it, do they?
Correct. They don't have a safety coordination plan that outlines the various responsibilities for that site. And almost invariably these days on modern work sites, construction sites, you always got multiple contractors working in the same space. So this is actually becoming more normal than it ever has been in the past with how business relationships.
And I guess the difficulty for us, Gary, when we look at the prosecutions we've been involved in, it's lovely that we have so much better infrastructure around safety, documentary infrastructure. So we have good templated risk assessment processes, but they have inherent risks, don't they? And that's the tick and flick problem with them.
Yes, absolutely.
Yeah, so I think if we can just remember, when you've got a specialist contractor, it's a bit like inducting a new player into a footy team. You say, look, this is who we are. This is why you're coming to our team. This is the role you're going to be responsible for. But in doing that role, you've got to comply with everything we do. Now, in respect to your role, tell us how you're going to do this, how you're going to execute this role correctly, so we understand, so that we can support you in that process. But please be interrogative. Please don't just go, here's your ticket, come through the door, check, off you go.
Yep.
Because that's liability.
Maybe, Andrew, if I could offer a practical explanation, and you can correct me if I've got it a bit wrong with the legal obligations here. So I've come back to Andrew's excellent example of a specialist contractor coming on site. I've worked as a safety engineer for most of my working career, so over 30 years. And occasionally people tell me, I'm not an electrician, how do I induct an electrician onto my site? I can't tell them how to do it. And Andrew's already said, we recognise that certain contractors have specialist skills. So people think it's not as important to induct them because they're a specialist. And we wouldn't care if they're a nuclear specialist or an electronic specialist or electrician. What the principal or host, site owner, host or principal contractor is responsible for is inducting the safety induction, site specific, for every worker, which is the site rules, which is the company's or host's site rules, not trying to tell them how to do their specialist job. And I think that's where people get confused, and they feel reluctant to induct an electrician, thinking, as Andrew pointed out, oh, they already know what to do, they will do it naturally. As Andrew pointed out, they know how to do the electrics. They may not be as au fait with the company site rule for either working at heights or confined spaces. Now, you may not deal with many confined spaces, but I had a question only yesterday, and one of my clients came to me and said their contractor said they don't have to fill out and get a permit for confined space entry. So we're all familiar, if you go into confined spaces, a confined space entry permit is both a legal requirement and a sensible, practical part of your safety system. So it allows somebody to vet the safety precautions. And the logic of the contractor was they have found a little clause somewhere that says if the tank or vat is brand new, just been manufactured, it's had no chemicals in it, so therefore it has no contaminants, and therefore it's not a confined space, and therefore we don't need to fill out your permit form. And so my client asked me the question, and what they failed to understand is that they had 100% control and management of that. It's their site rules that the contractor has to comply with, not the contractor telling them, oh, I don't have to fill out a permit for that because it hasn't had chemicals in it. So the view is, if the company says, no, we don't care whether it's a new vat or an old vat, you have to have a confined space entry permit. That is quite valid for the site owner, occupier, or their principal contractor to enforce an entry permit to that confined space. And as I've mentioned,
a great example, Gary, because it might have something in it, but when you're standing inside it, it might soon have something in it.
Yes, yeah, that's it.
Because the contractor doesn't control what goes in and out. The contractor just goes, and it shows. If we look at what reasonably practical means, so let's talk about primary duties. We'll talk about it in more detail, but it's the facts you've given are just wonderful to talk about. Yeah. So the primary duty that exists in all legislation, now that's in Fiji, that's in New Zealand, that's in America, that's in Japan as well, is to do everything that's reasonably practical to provide a safe working environment. Okay, that's the basis of it. Now it has different wording, but that's the net effect of what it is. Reasonably practical has 4 elements. 1, to identify a hazard. Okay, so as a principal contractor, you have a specialist contractor come in and you say, okay, our obligation is to work together to identify the hazards. In relation to the hazard of working in a confined space, we consider that as a hazard, which is overwhelmingly ours, that we must control because we control the egress and ingress on it. We control the electricity that's going to it. Yes, it's a confined space there, but it has a whole lot of things that feed into it. So we must work together to identify what those hazards are. And in respect of each hazard, item 2 in reasonably practical is, what is the level of risk that attends based on frequency and seriousness? Now, the reason you have a permit system is There mightn't be frequent risks in a confined space, but invariably the risk of serious injury or death is incredibly high, and the capacity to see into that risk is very limited. So we know straight away, item 2 on reasonably practical, very high risk. Okay. Now, when we look at the hierarchy of control, and not all legislation uses the hierarchy of control, but I will say to you, all courts use it, because all expert evidence is given through the lens of the hierarchy of control. What do we know about high levels of risk? They require a high level of control. They can have a short, very brief period of administrative control, but you can't stand next to a 200-foot hole and say, don't come near it, okay? You can do it for 2 seconds, 20 seconds, a minute, until you can actually put barricades around. You can stop it. You can't have someone standing there doing it. So we know with a confined space, it's an incredibly high risk. Therefore, the level of control has to be to prevent people from entering it until it's known to be safe. And what's that method of doing? It's a permit system. And the last element is the resources you apply in the organisation to be satisfied that the risk is controlled. So if you haven't got the resources to control it, you must stop, okay? But the person who has to control that risk is always going to be the owner of the premises, to be satisfied because of the interrelationship of that confined space with the other operations, to be satisfied people are doing stuff that's safe. So that's how reasonably practical works, to provide a safe workplace. Now, you also have to provide a safe system, so provide a safe workplace and a safe system. And as Gary said, the owner or the principal there has a system that says this is what's happened. Now, if that's the case, both contractually and at law, the obligation rests with the principal. So great example. Let's try the next one, Paul. All right, so we're going to get into this stage. I think, Gary, this is where we see the most mistakes happen. And that's certainly as you go to procure a contractor, there's some real issues that sit with that. Now, this is the problem with contracts, particularly with design and construct contracts, because somebody says they're going to be the design and person who's going to drive construction through their design. And the moment they say, look, I'm in charge of design, they've created a new duty, which is the duty to do everything reasonably practical in the design of the structure. Okay, so you're now wearing 2 hats. And then you're doing commissioning and construction, so you're up to 3 or 4 hats, and then you've got control of the site. So suddenly you've got 5 duties, different duties, all with reasonably practical around it. So when we go to procure someone, one of the things we must do in the risk assessment process is identify the work and who will be responsible for that work. Okay, now in most tendering processes, particularly in design and construct, there's a looseness that sits around that, because what you're asking is the principal contractor to actually solve the problem for you. But once they've solved the problem, you then must be very, very clear as to who does what work and who bears what risk in it. And it must be in the contract and then built into the back system of the principal contractor to say, my system complies with my contract. And what we normally see is they're completely different things. The system is a system they use everywhere they go, so it's the same system. And the contract has been modified and built around risk allocation. So it's entirely different than what is the system that actually exists. And this is when people are trying to manage, they get really lost. They go, well, wait a second, our system says you do this. You're saying the contract says you do that, and they rub their head and they go, I don't know what to do. So identifications of roles, responsibilities, and risk must line up between the contract and the process that sits behind it.
Andrew, could I ask you a question as well? I have a rule of thumb, and it has no, I think, legal status, but I say half of all safety is the documentation that supports that design. So it could be the drawings, the specifications for whatever the work is. And often we find, with ACTS investigations with yourself, is that the as-built, they don't have the as-built drawings. There was an original design, but modifications were made at the time of installation and commissioning, or possibly later. Do you have any thoughts on the value of that documentation for the members?
So look, I think there's a couple of bits of law which are really interesting. The law of contemporaneous evidence says that documents created at the time of the utilisation of that, and this is particularly important when you're doing site minutes, because site minutes are contemporaneous documents. It is evidence that you had the meeting, So it's evidence that your system's working, okay? It's then evidence the truth of what was said at that meeting. So it's an exception to the hearsay rule, and you can rely upon it when you go to court. Now, Gary's talking about a stage down from what I was talking. My problem, when I look at matters, almost invariably, there are two sets of standard documentation that are used in all construction work. One is the construction contract, which is amended and modified to shift risk and cost, okay? So it's got a number of slides in it that you pull in and out, depending, you're responsible for that, I'm responsible for that, that's where the cost falls. And then you have another set of documents, which is the system, but the system has never been modified. So here we have a risk shifting device going on over here, and here we have one which is the same absolutely every time. And the next problem that happens is, because these documents are massive in construction, variations will be granted. They'll often be oral variations. Remember, all contractors who come to a major construction contract, and I used to be a building construction lawyer, so just excuse what I'm about to say if you disagree with me. You drive, I used to draft our parts of the contract so that we could drive our margin through variations. So I'd push back on geotech and say, no, your responsibility, your responsibility. And the moment we had an aquifer or something come up underneath, I'd go, variation, we need that, you know, liquid. And so all forms of contracting make money through margin. So make money through the margins they get out of variations. That's why it's so important to do two things. One, update the documentation as you go to vary something, and design and construct. This is the nastiest litigation that ever comes in a building construction thing, is around changes in design to deal with problems that arise on the go. Well, that's terrible in building construction, but in safety, it's absolutely terrible because there's been no modification. And usually these things are governed by SWMS because they're high risk construction work. And there's been no modification to the SWMS. So the SWMS, as Gary said, identify a risk which doesn't exist anymore. There's a new risk, but no one has updated the SWMS before they commence it. It's just been fluid. They've gone, look, we can't get around the corner doing it this way. Okay, well, let's dig a trench there. Yeah, okay, let's do that. So the building construction contract, disaster. When they come to do the assessment of what the entitlement was, no proper process was followed. But even if it has been followed, no one's changed the SWMS, and therefore someone gets killed. Morally shocking. In safety terms, it is the biggest risk waiting to happen, and that's because, as I said, it's like two trucks turn up. One turns up and it tips out the contractor building construction, and it's all been stuck together so it works perfectly, just what you want, as long as everything goes to plan. The next truck comes in and it just drops the process, and that never changes. No one ever amends it, they just go with it, even though it no longer complies at all with what's being done. So please be careful with that. The other thing I try and do when I'm acting for contractors to give them some control over their work is to isolate and say, well, you have complete management control over the area you're changing that light in. So by doing that, what we say is, now you demonstrate to us that your system does everything that is reasonably practicable in that space to provide a safe place of work for you and for anyone who comes into that space. And in doing that, I've carved out. I've moved the responsibility as long as I have reliable evidence that that person is able to do that. Now, when we're using small contractors who've got no safety person, no systems that accept the off-the-shelf one, you know that's not the case. So they always stay your responsibility. The other thing to look at is, what is the specialized skill, and do we have that specialized skill? Now, you've got to do that analysis, because if you do have a specialized skill, you do have a lot more responsibility that comes with it. You must look at the testimonial experience of the knowledge, the experience, and the performance of this work by a contractor beforehand. And again, Gary, when we look at local government work, for example, that we've done in the past, we commonly see, because there's a focus on procuring people in the local community, that the backhoe operator has dug drains before, but they've never done a 5-metre trench. And yet suddenly they're here doing a 5-metre trench, and they're a mum and dad operator, and they have none of the skills that are necessary. But nobody testimonialized and said, go back and show me what's the work you've done over the last 6 months. Show me that you're doing like and like. What do you think, Gary? I think that's where the biggest gaps really sit for me.
Yes, I think what you've pointed out is moving to the smaller contractors, and what you've just mentioned, the assessment of them, of their capability. and, if you like, resources to deliver whatever the project is. And I think you pointed out earlier, it's okay to use those small subbies. It just means your efforts to supervise them and ensure the systems that they've got are relevant and correct and followed is a bit higher, I think, for those smaller businesses.
The problem is, when they do get a bit higher, they're actually yours. Because if you can't say when someone lands on your site that they are competent in safety and managing their work safely, then they stay yours. And therefore, it's not monitoring them, it's supervision, okay? They are actually yours. You can't let go of them, okay? If you can't prove these things I'm talking about, you've really got some problems around them. And you must have your own systems that do identify and rate risk and have methods of control in a reliable way that relate to the work that's being done, particularly in design and construct, where it's your responsibility. All right, let's go to the next one. All right, very, very simply, now we've got a contractor on site and we know that contractor is competent in safety and is able to do the job safely and can do everything that is reasonably practical. We know that when they come on site, we give them induction, and Gary's already talked about the induction. You're inducted into site, you're told what you're responsible for, what we're responsible for, and what we expect of you. There's an implementation process, which is the risk assessment process that goes on from there. So now you're on site, this is what it looks like. Now let's implement, this is what you're doing, this is what we're doing. Let's document it, let's get it right. Let's be satisfied that the people who actually come to the site are competent. Now remember my warning about subcontractors? A very capable business overextends itself and it gets a whole lot of jobs. So they've got everything right at the procurement side. They turn up at induction and they're terrific. And day two, there's no one who is there on day one, and there are a bunch of bums who've turned off, they're dragged in to finish the job because they're short-staffed. What's happening with them? How are we managing them? The next part is we must monitor, we must have site-based meetings and ensure that the systems that are being used by the contractors match together, meet the total coordination plan, and that it is safe. Now, we don't supervise and say this is how you do the work, unless they're one of those smaller contracts which we're just going to accept are our risk. But for a major contractor, they've got to demonstrate their systems are working every day. That's what they've got to do. They've got to satisfy and have a report card that demonstrates that, and at site meetings, it needs to be shown. Any failure in safety is always a contractual breach. And therefore, the obligation of the person who is managing the contractor is to point to the contractual breach and say, show me what system you're going to utilize to fix this. Not go in and fix it yourself. If you're worried the danger is too high, tell them to stop work. Yes, there's a risk of liquidated damages, but that can be fought out by the administrator of the contractor at a later time. If it's a contractual breach, like a traffic management system that's creating an immediate risk, stop work. Nothing will focus a contractor's mind as fast as being told to stop work and get it right. But what you're after is not creating the solution for them, it's getting them to explain the system that fixes the problem for you. Okay, let's move on to the next slide. I think we're getting closer towards Gary territory as we speak. Okay, we've talked pretty much about them, so let's move on from that. Okay, I guess this is where we're starting to move, where nearly every bit of work that you'll be involved in has more than one contractor who's involved. And I guess what we're trying to say is, well, look, how do we make sure that the principal has a control plan for all people who enter the site, that manages all of the risk of the site, that is exposed by the different skilled practitioners who are on site. And Gary will talk about that a little bit more as we move towards the end, okay? But it's the principal's obligation to monitor and manage the site, even if they've given over control to a major contractor. So they've given it to Leighton and they said, your job. Doesn't mean they don't have to monitor and manage the site, because they've never been able to get rid of the responsibility. So what they've got to satisfy themselves is, day one, were they competent safety people doing everything that's reasonably practical? And through the life of the business, did they continue to keep up that level of competence and capability throughout it? That's monitoring and managing.
Andrew, can I ask you another question as well? I get asked this quite a bit. My clients say, you know, in Victoria, you legally have to have a principal contractor, PC, above $350,000 for the project. In most other states are about $250,000 as a trigger point. And some of them seem to have this interest to split the project out to try and not have a principal contractor. My view is they should seek to have a PC, a principal contractor, not the other way around. What's your view on?
Absolutely. I mean, the idea of splitting, risk splitting is a clever thing if you're talking about 350 million. Okay. If you're talking about $1 million, $2 million, you want somebody who's highly competent managing that site. A $2 million contract with a 10% margin. Okay, so $200,000 margin. That's a $200,000 margin across a number of businesses. There's very little safety expertise you're bringing onto that site. When you're bringing in subcontractors doing $40,000 worth of work or $200,000, they're not going to have the competence. So the idea of having a principal contractor is to ensure the site is safe at all times. To not have a principal contractor for a complex site at 2, 3, 4, 5 million means, gee, you're in a lot of strife, aren't you? You're in a lot of strife at that stage. So the other part is legally, the regulators will look towards the substance of what you're doing, not what your contract says. So if the site's really a $600,000 site, but you've split it into 2 parts, but actually what's being done is really $600,000, the legislation and the regulator are disinterested in your contract. They're interested in the truth of what's happening. So
I like that response, Andrew. I tell people I don't care how low the value is of the project. Could be way under the 350,000. I said you want somebody holding the baton who is clearly in control and managing and supervising safety on this side. You want somebody holding the baton.
That's right, Gary, because you can, as the principal, you can never let go of it. Yeah, so unless there is somebody managing it, you've got to be there every day.
Yeah, that's it.
Not too bright to me. Okay, next one. All right, I just want to go very quickly about what a system is, because people misunderstand systems and think they're documents. A system of work for safety at a high level is your total safety plan. But if it's at a site level, it's the coordination plan. So it says, what is the plan that's managing this site? What are the processes that evidence that plan? Is it a SWMS? There's policies and procedures. There may be some safe operating procedures. But what is the process that fits underneath that plan and plugs in to make sure that you're doing everything that is reasonably practical? Because remember, if you do everything reasonably practical, you can't be liable for industrial manslaughter either, because you've got to have a breach of duty. You can't be liable for reckless endangerment, right? Because you're aware of what the risks are. You're not indifferent to what the risk is. There must be then evidence of education, of induction, of competence-based training for the people who are doing the work, because driving a backhoe for a highly skilled person is a very safe occupation. But if I get in and drive a backhoe, it's pretty dangerous, okay? So the idea is we've got to be satisfied that people working on site have not only been trained, but because of, in Victoria, the subjective test of due diligence, everywhere else, the objective test of due diligence, unless I can be satisfied that people know what they're meant to be doing, inducted, are trained and competent in what their job are, I stay liable as an officer of the organisation. I can't get rid of that liability, because the first question I ask as an officer is, are the people who are working on site competent to do the work they're doing, and what is the evidence of that competence, okay? Beneath that is supervision. So now I've got somebody who's saying, I've got people working for me. Do they know what the plan is? Are they following the processes? Are they competent and capable? Are they doing what I'm directing them? Supervision. I need something that monitors that to make sure that it's working. So are there walkthroughs? Are there daily site meetings? What are the things that monitor whether the system, the plan, process, the capability is being managed? And then I have reporting back against that plan. Now remember, we talk about reporting as lag indicators like lost time injuries, footprints in the snow, meaningless rubbish. It's the plan that tells us whether we're safe. So if we say this is what it looks like to do it safely, and it's not being done safely, that tells us before someone gets injured, there's a risk, okay? So reporting goes to the lead indicators of plan, process, education. That's where all the high risk is. And if you injure somebody, well, we know what's happened, okay? We know something's gone wrong. Now, when Gary and I talk about a system, that's what we're talking about. Okay, let's go. Next one, Paul. Okay, Gary, have a talk to us about high risk and what it means.
Thanks, Andrew. I put this slide in because I think many people out on the work site are hearing lots of things that have the term high risk in it. So to my mind, there's this thing about high risk language. For example, you'd have a high risk activity. If you're in the circus and they're covered by the Workplace Safety Act because they're paid to do it, the acrobats and the guy fired out of the cannon, I think that's a high risk activity. We hear the term high risk work. That's actually in the regulations in all jurisdictions around Australia and New Zealand. And it's actually licenses for high risk equipment, but they call it high risk work, which is with that equipment. So for example, forklifts, crane licenses, scaffolding, rigging. So there's high risk work. And then you hear there are high risk areas, and that could be a confined space. It could be a flammable environment, something of that nature. Then you get to high risk equipment, but it's not high risk work. So earlier, the license for the forklift, I give often an example of a chainsaw. A chainsaw is inherently dangerous. You know, potentially it cause serious injuries and fatalities, but there is no license category for it in any jurisdiction around Australia and New Zealand. So there's no license, so you've got options of how you train people and authorise them to use it. But as Andrew's pointed out earlier, just because there is no license or no formal process doesn't mean to say you don't have a safety system in place to control those chainsaws. So you either do internal training for a chainsaw, or you send them off to a TAFE course or some other training institution that's competent to train them in how to do it. So when there's no license, don't assume, oh, there's no license for an electric drill. There's no license for a large angle grinder or whatever might be used on your sites. That doesn't diminish the requirements to put in safety systems. It actually increases it because you can't rely on the license as a sign of competency for that person. And now we get to HRCRs, which is high risk construction work as a language. Let me tell you that SWMS are covered under high risk construction work, and they appeared in the language in Australia for the first time about 2008. We've done some recent research on this, Andrew, and we cannot find in any jurisdiction around Australia or New Zealand the term SWMS before 2008. So it appeared in Victoria, and then it appeared in 2011 in the harmonised safety laws. Have you heard of it earlier than that, Andrew?
Drawn from Victoria.
Yep. So, yep, indeed. So that's the language. I just want you to understand people are using high risk and connecting it to a number of things. So let's just, if I can have the next slide, please, Paul. So high risk construction work, which is often that abbreviation HRCW, is 18 defined activities, nothing else. 18 defined activities. If you're in Victoria, it's 19, only because they've split trenches and tunnelling. Other than that, so when people talk about is there 18 or 19, that's the slight difference. So each one of these is defined as to what it is. So it's not just a trench deeper than 1.5 metres deep. That's not very deep. Falls risks, it's not all falls risk, it's greater than 2 metres, although if it's in South Australia, 3 metres. And so they'll have powered mobile plant, by the way, is defined in each jurisdiction as what is planned. And it's a little bit different in each jurisdiction, but that's okay. So that's what is high risk construction work. So if I can have the next slide. Thanks, Paul. So when's it mandatory? I'll just hand back to Andrew because I'll let you do the legal bits and I'll just try and provide some practical examples.
All right, so SWMS, that's pretty easy actually. It's just said there, isn't it? It's definitely mandatory for high risk construction work. It's mandatory to do a SWMS both in Victoria and throughout Australia and in New Zealand. A JSA, just to be really careful, job safety assessment, is never mandatory. It's language which is contractual rather than statutory.
Thanks, Andrew. I just thought I'd let you add that little bit in before I proceed.
It's really fun, actually. Good.
Thanks. Paul, if I can have the next slide. So thanks. So picking up what Andrew said, and this is my simple language, and Andrew is often offended by my simplicity and as in legal matters. But JSAs have existed for decades and maybe 100 years, and the terminology, certainly 50 years. and they're defined by company standard. And this is why there are so many opinions and variations and versions that you'll see of JSAs around industry, is because it has never been defined in an Australian standard, and it has never been defined in any of the regulations. So therefore, what you call a JSA is what you choose to call a JSA. What you choose to use a JSA for is your choice, although it is intended, as Andrew explained earlier, to step out step by step how to do the job, what are the hazards involved in the job, and how to control them. Interestingly, that's very similar to what a lot of people are using SWMS for, but I'll now come back to that. So number one, why is there confusion between JSA and SWMS? SWMS have come into being only about 10 years ago, into the language around workplace safety. JSAs existed a lot earlier, and so people were confused and wondering, which one do I use and how do I use it? So number one, SWMS is a legal requirement if you're doing high risk construction work. It is not a legal requirement outside of that. So you might say, okay, people will use JSAs for non-high risk construction work, and will use SWMS if it's one of those 18 designated high risk construction work. The problem is, as Andrew said, the systems for most businesses are fixed. The task is changing every day and every hour, but your SWMS is pretty well written. I wouldn't say in concrete, but we type them up, we prepare them well, we present them to people, and we ask them to sign off on them, which is not a legal requirement, by the way, but I'll come to that. This slide is just about why is there confusion, because SWMS is a relatively new term, not understood, and people were not quite sure how to marry that with a JSA. Do I need a SWMS and a JSA for the same job? The short answer is, I think Andrew will agree, no. You just, as long as you've got a safe system of work, we don't care which one you've got, how you've got it. But if it is high risk construction work, the law says you need a SWMS. But interestingly, unless Andrew corrects me, the document doesn't have to say SWMS at the header, as long as we can show that it has the features which are mandated for a SWMS.
Gary, I think that the reason that there is such a distinct difference between JSAs and SWMS is historical too, and that is risk as a concept emerged around about 30 years ago.
Yeah.
Legislation that we currently use started in 1970 in England, okay, and it was based on really a financial modelling of safety, okay. So and had two concepts: one, if I care for the welfare of my staff, they'll come to work and they won't hurt themselves, and if I provide a safe workplace, I won't do any damage, I won't dislocate my work, I'll have a highly productive workforce. And they did a whole lot of research in 1970, and that's what they said. But safety practitioners came to life about 30 years ago. So, 30 years ago when I started doing law, there was not many safety experts around. And they came and said, look, the most important thing is to look at what the highest risk is. So JSAs historically have looked at a job based on highest to lowest risk, whereas what SWMS is an ambulatory document that says, this is how I start the job, this is where I finish. And we'll go through every task and analyse risk on the way through. Now, obviously, if you have JSAs that go to higher level risk, they're going to move much closer towards template-driven behaviour, where people start to tick and flick. Because they go, these are the high risks on their workplace. They look at a machine that they're commissioning and they go, yeah, same as every other machine. Off we go. Tick, 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 tick. Whereas when you do a SWMS, you've actually got to go and do an inspection. You've got to consult with people. You've got to actually get everyone in line along the process. So the likelihood of you picking up real risk is much higher with the SWM than it is with the JSA. Now, JSAs are every different shape these days, aren't they, Gary? Some of them are actually SWMs.
And in fact, I've got a template I'll just show everyone in a moment, which might reinforce your point, Andrew, I think. So, Paul, if we could have the next slide, which I think we've actually spoken to, but I'll just let Andrew finish off in case there's anything else that you wanted to make there, Andrew.
Yeah, look, all I really wanted to say is I like SWMs, and there are less risks around SWMs when we look at serious injury and fatality, because people go in chronological order to look at what is actually being done operationally. It means it's harder to template it. It demands a site inspection, and it involves each person who's involved participating in the process. I know that should happen with JSAs, but that's not what happens with JSAs, and it's JSAs that we commonly find are the ones which are flawed, fail to pick up particular hazards, fail to accurately assess risk, and fail to engage people correctly, and they're seen as ticks and flicks. So we started this whole idea of having a discussion around it because of my last 200 serious injuries and fatalities I've dealt with, nearly all of them, to the extent that they had a risk assessment document, nearly always they were on the JSA category of it, or they were somebody who didn't do swims at all in a high risk construction. Over to you, Gary.
Thanks, Andrew. Good explanation. If I can have the next slide, which is my attempt, Andrew, at a template. So actually, what the swims contain. Yeah, if you can just click it again, Paul. I do apologise. I ended up with some animation. So I think that's it. So in essence, legally, a SWMS, it doesn't matter what jurisdiction, I've given the citations there, has to identify the high-risk construction work, e.g., I'm working on a roof and there's falls greater than 2 metres. That's what you have to identify. I've already actually now mentioned the hazard, which is obviously I can be killed or injured if I fall off the roof. The controls of how I'm choosing to control it, and that SWMS has to be readily accessible and understandable for the users, which necessitates it, in essence, it's going to be succinct. And I don't know about you, but I've never seen a 20-page SWMS or JSA in the back pocket of any worker ever that's been consulted in the field.
And not only that, Gary, with all the safety jargon chucked in.
Yeah.
You know, like we had a matter come through about 3 months ago, and I looked at the SWMS, and I've written 2 books on safety, and I didn't have a clue. I didn't have a clue what they were talking about. It was all acronyms. I'm there going, now imagine if I'm a bloke who's just digging a trench. What chance have I got of understanding that?
Yeah, indeed. So if I can have the next slide, Paul, I'll actually show you my attempt. The bits in yellow are the bits that are only the bits that are required by law. So to be a valid SWMS, it must identify what is high-risk construction work. You'll see in the column in the middle, HRCW1, HRCW2, HRCW3, whatever it is. And the first example is I'm working on the roof and someone could fall greater than 2 metres. So I've now, I've identified the high-risk construction work, I've identified the hazard. Now you've got to outline your controls and how you're going to implement it. So in a short sentence, I've got here, display signage, no entry to the roof without a permit at each access point. So wherever the access points to the roof, I've got a sign that says don't go past here without a permit. So if I catch you up there without a permit, I've got clear cut, are you compliant or not? And the permit to include the precautions, which could, for example, be everyone is trained in roof access and emergency procedures, and we either have handrails provided or we have fall restraint harness worn at all times on the roof. You have a choice. You're either going to have handrails up there or we're going to have a fall restraint system. And the bit down the bottom, WA add, you've got to show the equipment, the training and the qualifications on the SWMS. So you just need to work out how to put that in. You'll notice at the bottom, the work team daily sign off is not in yellow. It's not a legal requirement, but it's actually a practical thing to do, I believe. I've not aired this with Andrew, but I actually think it is a good thing to do, but it is not a legal requirement. Who approved it, the date they did it is not a legal requirement. And what I'm showing is a SWMS or a JSA could be the same as long as they have the things in yellow. It's valid for a SWMS. Andrew's pointed out his disappointment is historically and through his cases, a lot of the JSAs have not been thorough enough, have not actually identified the risks that actually eventuated into these serious accidents, or the controls were inadequate.
Gary, can I just say, this is what legally you put on it, but in a prosecution, if I'm running a SWMS for an entry to a site, and I fail to have the evidence that people have been engaged and inducted into the SWMS as they come on site and participate in the process, the document has no meaning.
Yep.
And the document isn't contemporaneous evidence of people's agreement or acknowledgement of it. And so that's the key. So yeah, I don't want people signing off just so they get their pen and they go, put the line. I don't want that. But you've got to create evidence of the knowledge. So when Gary comes onto the site, Gary comes in at 11:26. It comes on here in the induction, Gary 11:26. Reviewed SWMS with Andrew Douglas, 11:30 to 11:35. Sign off, Gary. Okay. regulator comes in, there's Gary's been injured, and they go, oh no, wait a second, Gary did stop. Here's contemporaneous evidence that he stopped. It was Andrew who was in charge in inducting him. Here's the induction process. He's read it and he signed off on it. So yes, it's not legally required to be done, but if you don't do it, you don't have the contemporaneous evidence of the acknowledgement of the responsibilities, and therefore there's no transfer of risk. The risk stays with the principal.
It's a very good reminder, Andrew, and thank you for that. The other one I'll show there in red on the right-hand side, the risk matrix is not required nor helpful either on a SWMS or a JSA. It is a total waste of time to show me a separate matrix and a risk level for going on the roof, to using a drill, to climbing on a ladder, to opening a can with chemicals. What we want and what the law requires, you've identified the hazards and how you're going to control them, not what the risk level is. So any SWMS or JSA that even attempts to try and waste your time with a risk matrix and the level is wasting your time, because you're doing all the steps. To do the job, you are doing all of those steps. A risk assessment, separate thing, a risk assessment that I might do before a major project or task, I will use the risk matrix and I will understand the risk levels at each stage, and we might put controls in. But once we have decided on our work practice, on our work procedure, this is how you do it safely. You do not have to. So the job overall is either high risk task or medium or low, but not each step within the procedure.
You don't understand reasonable practicability, is because here you're saying, this is the hazard, okay? I've done a risk assessment beforehand, and that tells me what is the control that I need to control the level of risk and the resources I need. So all I need to know is what is the control and the resources, and then I must comply. Knowing the risk, I mean, it may or may not be helpful. It may trigger someone's mind a bit more, but the bottom line is we've put the controls in after doing the risk assessment. So it's the controls that must be followed. And the more information you put in there, the less likely people are going to do it.
Yep. Complexity is the enemy of safety. I heard somebody say. Yep, there we go. And that's my last slide, Andrew. And I thought if there was any questions, we might check with Andrew or Craig.
Just to say, guys, if you press Friday when you get this, you'll actually connect directly through to the registration for the Friday briefing. So feel free, and do follow. Gary's also on LinkedIn. All our articles, and there's usually 2 to 3 a day that come out from our law firm on workplace law, usually those on safety as well. So for those interested in JobKeeper and in the various restrictions across Australia, you'll find both on our website, LinkedIn, and regularly on Friday we update those with documents for you. So I just thought I'd give you a heads up on that before we start. Okay, over to you, Paul. Questions? I think it's Craig, actually.
Hi guys, thank you very much for that. No, look, we just had one question earlier on about getting a copy of the slides, which I've responded to anyway. So I'll just give everybody the opportunity now. If you've got any questions from the session there, just to pose them right now. If what often happens, they creep into your mind after the fact, please feel free to email them through to myself or Paul, as Paul mentioned at the start, and we'll pass them over to Andrew and Gary to respond to later. So I'll just leave this here for a second, just to see if anyone wants to type in any questions in the final moments of the presentation. I mean, you did a fairly good job there, guys. You know what I mean? There was a lot of questions and answers straight away, so I think you knocked a lot of that on the head straight away, right? It's,
Craig. I don't think everyone's asleep. I don't think that's true at all. Gary and I are the portable anaesthetics. We can put anyone to sleep. We've got grandchildren.
Well, no, I think maybe you've got off scot-free.
Ooh.
As I said right now, but you know, like I say, don't count yourself too lucky. There might be some questions coming down the track, so be prepared, I guess.
Okay. All right. Thank you for the opportunity, Paul, and thank you, Andrew. Thank you, Craig, as well.
Good to catch up again. Cheers.
Let me just make a few concluding comments. And first of all, thank you both to Gary and Andrew for that very insightful presentation. I know it's a monumental topic, but as we specified at the outset, we know so little about these issues and our responsibilities, and far better to know of our responsibilities than to find out the hard way afterwards if we've had an incident that we have no idea what to do. So I guess prevention's far better than the cure. This sort of speaks as to what this is all about. BICSI is a resource centre. It is a facility where people who have information can disseminate information to those who need information. We see that on a technical basis regularly. Here we've got it from a legal and from an OHS perspective or a workplace environment. So by all means, you'll see the little notes at the bottom on that slide. If you need to speak to either Gary or Andrew or their team, by all means reach out to them, or through us, we can facilitate that. It's something we can't ignore. You know, I think Andrew, you said, ignorance is no excuse. It's always been that's a classic truism in the legal world. If anything, if we haven't had a problem, it's probably just luck. But sadly, often it happens, and we'd rather have people know how to prevent a situation than have to deal with it when it comes to safety. So that's very, very important. Just as a reminder also that next fortnight, so 2 weeks' time, which is the 25th of August, we have another BICSI South Pacific webinar. We're looking at containment of or air containment in healthcare services or healthcare facilities and data centres. Another one that's important to have a listen to learn a little bit about. We will basically, we haven't got the schedule going beyond that. We've kept it blank for the moment. And just something of note for the cablers who have attended today, the wiring regulations, the ASCA S009, it's been 2 years in the remake. It was signed off last Friday, so it will be released soon. So it'll be S009 2020 will be the regulations for installation of cabling product, and S008 2020 will be the regulations for product itself. There are a lot of changes that have been brought about over the current versions of these documents. We're going to bring on board the chair of the committee for that, Murray Teal, who many of you know. We're going to have a couple of seminars, or webinars, should I say, to address that. So we'll get that information out to you shortly. So once again, thank you to Gary and Andrew for their very brief. I'm surprised how brief we're able to cover such an enormous topic. I'm sure everyone's got information from it. And just to remind everyone, we are recording this at the moment, so you will be able to access the recording. Somebody requested the slides. With Gary and Andrew's permission, we'll pass on those slides and you can look at that. And importantly, feel free to take advantage of the resources that both Andrew and Gary provide to ensure that we work in a safe place and our businesses are protected from the challenges. So with that, I'll conclude and thank you all again for attending. Many thanks.
Thanks very much. See you later, everyone. Bye-bye.
Thanks very much, everyone.
Bye.